And the fifth writ, the last writ conferred by the Constitution to the Supreme Court and the High Court, is a Quo Warranto. Quo Warranto means by what authority? So, therefore, by knowing the meaning, you could understand that the writ is issued to take the office back from a person who is holding it without any authority. That means, if any person occupies a public post or a position without any proper qualifications, we could ask for writ of Quo Warranto. So, Quo Warranto is a judicial order issued by a person, issued by a court to a person who is occupying any post or a position, to asking him on what authority he or she holding such an office. That means, by issuing that writ, the court would ask the person, show your authority. Why? How did you acquire this office? Do you have qualification? Whether your appointment is properly done or not. So, therefore, the aim of the writ is to oust the unauthorized persons from the public offices. The reason is very simple, that the public offices should be occupied by the qualified persons, because their salaries, emoluments are paid from the public contribution. So, Quo Warranto confers the jurisdiction to the court to control the executive actions in matters of appointment to the public post. It protects the citizens from holder of the public office to which he or she has no right. So, writ of Quo Warranto could be used to scrutinize when qualifications are prescribed for a post, whether these qualifications were fulfilled. So, let us come to what are the conditions for granting Quo Warranto. Number 1, the office must be a public office. Number 2, public office must be substantive in nature. That means, it must be permanent in nature. It is not terminable at the will of the person. It must have an independent name. The third ground is that the person must be in actual position of office. That means, unless until the person actually acquires the office, you can't ask for writ of Quo Warranto. Therefore, mere issuing an appointment order is not sufficient to ask for writ of Quo Warranto, unless that offer is accepted by the person and acquire the office and assumes the office. And the fourth ground is, the person must be holding the office in contravention of law. That means, if he is holding the post in violation of the law, that means you have to show that there is a violation of a law in holding this post. Then comes the same question like in other writs, who could apply? Who could ask for writ of Quo Warranto? The writ of Quo Warranto is different from other writs. Therefore, from the beginning, the writ of Quo Warranto could be asked by any public spirited person. That means, any person can ask for writ of Quo Warranto. So, the petitioner need not show that he has a locus standi, and petitioner need not even be qualified to acquire that post. So, therefore, if I question the appointment of a public post, even though I did not apply for the post, I am not qualified for the post, is fine. The reason is that they should not misuse the public funds. Therefore, if anybody is misusing the public funds by assuming an office without qualification, every public has a right to question his authority. However, this writ could not be asked if there is an alternative remedy is available. For example, a writ of mandamus cannot be issued against a member of the legislature. In V.D. Deshpande versus State of Hyderabad, the court said, in such a case, Article 192 gives you an alternative remedy where the speaker can take a decision. Similarly, when the office is not a public office, you cannot ask for writ of Quo Warranto. And the third circumstance where the writ could not be asked is when issuing of the writ is futile. For example, the best example is that P.L. Lakhanpal versus A.N. Ray, Chief Justice of India, when Justice A.N. Ray was appointed, superseding 3 senior most judges to the Chief Justice of India, a writ was asked, a writ of Quo Warranto was asked by the petitioner. On what authority Mr. A.N. Ray is assumed the office of Chief Justice of India. Meanwhile, when the writ is before come to the hearing before the court, the 3 senior judges who are superseded by A and Ray resigned for their post. So therefore, the court says that even if they issue a writ today, A and Ray being the senior most among the existing members, the writ is futile. Hence, the High Court refused to accept the petition. So therefore, if a person who acquires the office, and if you want to ask the writ of Quo Warranto, if issuing of such a writ of Quo Warranto is futile, there is no need to issue writ, hence the court may refuse it. So now, these 5 writs we have discussed, we knew that these 5 writs are issued for different purposes. Let us pause a little while. We have so many writs we discussed, we have so many things to do, but if you look at the Constitution has made an elaborate provisions regarding the judicial proceedings to prevent miscarriage of justice in India. For example, Article 32, 136, 137, 141, 226, 227. There are many other provisions which talks about how do we prevent injustice and how do we provide access to justice. But my question is, suppose you use all these provisions and exhausted all the provisions, but still you feel that there is a miscarriage of justice. You suffer the injustice due to abuse of the process of law. Do you have any remedy? So that means you went from lower court to the High Court to the Supreme Court rejected, finally you filed a review petition, Supreme Court not accepted, everything is done. In spite of that, you feel that there is injustice caused. Do you have any remedy? It doesn't look like. But this question that was raised in Rupa Ashok Hurra versus Ashok Hurra, where the Supreme Court has invented a 6th writ, which we call it as a curative writ. Now the issue involved in this case is whether an aggrieved person who entitled a relief against a final judgment of the Supreme Court after the review, do he has any remedy? Can he approach the court? And if the court comes to conclusion that there is a miscarriage of justice caused to this person, even after the final judgment of the Supreme Court, what kind of writ should be issued, if at all the writ is possible? Can you think among these 5 what writ could be issued? Let us look into whether certiorari could be issued, because it is the only writ that quashes the orders of the other court. But the problem with the writ of certiorari is, as we discussed, the writ of certiorari is a order by the superior court to the inferior court quashing its order. Therefore, can you ask the Supreme Court to quash the orders of the High Court? Not possible, because both are constitutional courts, they are not subordinate to each other. And a similar reason, can you ask a Supreme Court one bench to quash the order of the another bench? Not possible, because there is no superiority or inferiority among them. Can one High Court issue a writ against another High Court? Not possible. So therefore, the writ of certiorari is not possible to be issued in these cases. So does it mean that the aggrieved party has no remedy even if the court feels that there is a miscarriage of justice? And the another question is, do you think that Supreme Court, after careful examination of your facts, everything, with so many times it come to the court, could still be caused a miscarriage of justice to the persons? So this is not to suggest that the courts are going to do miscarriage of justice, but they are also human. They are supreme but not infallible. Sometimes there could be an error which requires to be rectified. Therefore, in spite of Article 137, could you ask for the writ from the Supreme Court? So the Supreme Court in the Ashok Hurra's case allowed the petition under the name of curative writ petition. It says that the judges of the highest court do their best, subject of course to the limitation of human fallibility. Yet situations may arise in the rarest of rare cases which would require reconsideration of the final judgment, so set right the miscarriage of justice complained of. So in such a cases, it would not only be proper but also obligatory on the part of the court to rectify the error. Therefore, the court says that in such a rare circumstances, the writ of curative petition would be entitled. So, when you can ask for writ of curative petition, when you can file a petition for a curative writ is when there is a violation of principles of natural justice, in that he was not party to the dispute, but the judgment adversely affects the interest of the person. Suppose he is party to the dispute, but he was not served the notice of proceedings, and the matter of the proceedings as if he has no notice. The third circumstance is where in the proceedings a learned judge failed to disclose the connection with the subject matter, that means bias, the violation of the first principle of natural justice. So, that may give scope of apprehension that the judge interest may adversely affect the petitioner. So, in those cases a curative writ could be asked. What is the procedure? The procedure for the curative writ petition is that the petitioner must establish those grounds what we have discussed earlier, that these grounds was raised in the review petition, but in spite of raising these grounds in the review petition, still the court did not consider them. And the curative petition shall certified by a senior advocate with regarding to the fulfillment of the above ground, that above requirement is fulfilled, the senior advocate should certify it. And the curative writ petition has to be first circulated to bench of 3 senior most judges in the Supreme Court, and also the judges who pass the earlier judgment on which the complaint was made, if the judges are available. And by a majority of the judges on the bench concludes that the matter needs hearing, then it would be listed from the same bench as far as possible. That is, which passed the appropriate orders earlier, the same bench should be constituted. The bench at any stage may seek the assistance of any senior lawyer as an amicus curiae. You now understand that the writs are not ordinary remedies, they are extraordinary remedies, because they could be exercised by a selected few. And mostly these writs are remedies against the state action. So, if you carefully follow the lecture, we could easily sum up that the writs are a good way of ensuring good governance and providing access to justice. So, it protects the rights of the citizens, and there was a demand to confer such power even to the district courts, because the people realized the value of the writs and the importance of the writs, and they knew that the writs are having a greater role to play in providing access to justice. Therefore, approaching to the High Court or Supreme Court in many cases may be difficult. Therefore, they are requesting that such powers could be given to the district courts, which is constitutionally permissible. So, therefore, we have learned a great deal of writs, how these writs could be used. So, if you have any concerns regarding these writs or any other clarifications that you are required, you please feel free to write to us. Thank you.